All right, Mr. Morrison, are you able to hear me okay?
I am. Can you hear me all right?
I can, thank you. And then Ms. Morrison, if you could just unmute, please.
I think we might be good, Your Honor.
Okay, good, thank you. All right, we're on the record in Morrison versus Morrison. This is case number 2319363. The record should reflect we have both parties connected. This is set for a status conference today. The last time we had a hearing in my court was back in September. And at that point, we set it for a final hearing date here today. So I need to find out from the parties whether we've got agreements on everything at this point or whether we need further hearings. So Ms. Morrison, as the filing party here, can you tell me where things are at from your perspective?
Or another. My Wi-Fi isn't the best, so I'm not sure if you replied to me, Your Honor.
I wasn't able to hear really anything you said because you did break up.
Me and Jesse, we have not come to, or I guess we still have to meet up together to finish the paperwork, agree on it, and turn it in. So I believe we do need to have another court date.
Okay. Do you think that you're going to be able to reach agreements on things regarding the dividing of any marital assets or debts?
I want to believe so, yes, Your Honor.
Okay. Mr. Morrison, can you tell me where you're at with things?
I'm in the same boat. We are not completely agreed on things yet, and we just have to finalize and finish the paperwork to get everything through. There's just some things we need to work out still.
All right. Ms. Morrison, is 30 days enough time for that, or do you want more time?
30 days is perfect, please and thank you, Your Honor.
Okay, Mr. Morrison, do you think that's enough time from your standpoint?
Yeah, I think that'll be perfect.
Okay. All right, so I'm going to set this for a final hearing, excuse me, in about 30 days. The court will send out to both of you the notice of the date and time of that hearing. It'll be by Zoom, just as we're doing today. And what I'll need you guys to do prior to that date then is to submit the final paperwork. So that's the judgment of divorce, that's the final form, as well as a form from front of the court regarding any child support. So those are the two things that you need to turn into the clerk's office before that final hearing. And then we can finalize things on that date. Ms. Morrison, did you have any questions at all?
No, Your Honor, thank you.
Okay, Mr. Morrison, did you have any questions?
We know, Your Honor.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Susie, I'm sorry I forgot to bring you in for that last hearing. When the internet went down, everything got a little mixed up. Both
That's
parties.
okay. I watched you on YouTube, so thank you.
Okay, good, thanks. Okay, Mr. Burr, I am gonna need you to go onto your Zoom app and connect your audio. So Mr. Burr, if you can hear me, there's a button that on your Zoom app. You need to go into that app and there's a button that you press to enable or connect your audio. I'm going to need you to do that. Ms. Burr, are you able to hear me okay?
Yes.
Okay. All right, Ms. Burr, while Mr. Burr's working on getting his audio connected, I'm going to take the next hearing and I'm just going to keep you connected though and just mute you for now, okay?
Sure. Do you have a time frame?
It should only be within the next 5 to 10 minutes here. So
Okay.
I'm going to leave you right here in the virtual courtroom. I'm just going to mute you.
Okay.
All right, Mr. Young, are you able to hear me okay?
Yes, Your Honor.
All right, and Ms. Young, I just need you to unmute, please.
All
Okay,
right,
are you able?
I got it.
Yep, okay, great. All right, we're on the record in Young versus Young. This is case number 2319360. The record should reflect we have both parties connected here by Zoom today. I have this set for a final hearing to enter a judgment of divorce today. Mr. Young, as the filing party, is that how you wanted to proceed?
Yes, Your Honor.
Okay, and Ms. Young, is that how you wanted to proceed as well?
Yes, Your Honor.
Okay, so I'm going to ask both of you a series of questions. The questions I'm going to be asking are those I'm required to ask to establish the grounds for divorce under Michigan law. Mr. Young, because you're the filing party here, most of the questions will be for you at the beginning, but I will ask both of you to raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your Honor.
Thank you. You can both lower your hands. Mr. Young, you filed the complaint for divorce in this case and you signed that complaint. Is that true?
Yes, Your Honor.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Otsego County for at least 10 days?
Yes, Your Honor.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, Your Honor.
Does that remain true today?
It does, sir.
Okay, and you have 2 children who are under the age of 18, is that correct?
Yes, Your Honor.
And under the terms of the judgment of divorce, that you would both share legal custody and that primary physical custody would be provided to you with parenting time as the two of you agree with regard to Miss Young. Is that correct?
Yes, Your Honor.
Okay. And the two of you have opted out a friend of the court services, and that's been approved by prior order of the court. And you understand that that means that in terms of payment of any child support, that's going to be between you and Miss Young, and the friend of the court will not be enforcing any orders in that regard.
Yes, Your Honor.
As the father of the two children, do you agree that those provisions would be in their best interests?
Yes, Your Honor.
Okay, and then in terms of alimony or spousal support, you understand that you would not be receiving any alimony or spousal support as part of the divorce.
Yes, Your Honor.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor.
Okay, and do you agree that you and Ms. Young have divided up any marital assets or debts, and that there remain no disputes regarding that for the court to decide?
Yes, Your Honor.
And you don't currently own any real estate or real property together?
No, Your Honor.
Okay. All right, Ms. Young, were you able to hear all the questions that I asked Mr. Young?
I was, yes.
Were you able to hear all of his answers?
Yes.
And do you have any reason to believe that any of the answers that he gave were untrue?
No, I do not.
Okay. And in terms of custody and support and opting out of the friend of the court services, as a mother of the two children in this case, do you agree that those provisions would be in their best interests?
I do.
Okay. And do you agree that you and Mr. Young have already divided up all your assets or debts and that there remain no disputes for the court to decide?
Yes, we have.
And do you agree that you don't own any real property together?
We do not.
And are you currently pregnant?
I am not.
Okay. All right. The court finds that the statutory grounds for divorce have been met by the testimony of both parties in this case. I've reviewed the proposed judgment. Oh, Ms. Young, one thing I forgot to ask you, you also will not be receiving any alimony or spousal support. Is that correct?
Correct.
And you understand that you also would be waiving that forever and you could not come back later and ask the court for that?
I do.
Okay, thank you. The court again finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the judgment and other documents. They do comply with statute court rule. The court will grant the divorce. I've signed that judgment with today's date. That will be available here at the courthouse if either of you would like copies of those documents for your records. Ms. Young, the judgment indicates that you're going to have your last name changed. Is that correct?
Correct. Back to my maiden name.
Okay. So because the divorce is final as of today, your name is legally changed starting with today. So you may need a copy of that judgment to change your identification and other documents.
Okay.
Mr. Young, did you have any questions at all?
No, Your Honor.
Ms. Young, did you have any questions?
No, sir.
Okay. All right. Thank you. That's all for today. And both parties on this case are free to disconnect at this time. All right. I think we have Mr. Burr. I think he connected by phone. Mr. Burr, are you there?
Your Honor, this is Mr. McLaren.
Okay, I'm sorry. I'm going to put you back in the waiting room for right now. I'm looking for Mr. Burr. So Ms. Burr, I don't see Mr. Burr connected. Do you have any contact with him? Have you been in contact with him by phone? Do you have any way? Oh, here he is. Okay. Okay, I think we're getting things going. Okay, Mr. Burr, I just need you to unmute now then, please.
All right.
Okay, are you able to hear me okay?
Yep, now I am.
Okay, great. And Ms. Burr, you're still connected, is that correct?
Yes.
Okay, all right. So we're back on the record in Burr versus Burr. This is case number 2319386. Both parties are now connected by Zoom video. I have this set for entry of a final judgment of divorce. And Mr. Burr, as the filing party, is that how you wanted to proceed today?
Yes.
And Ms. Burr, is that how you wanted to proceed as well?
Yes.
Okay. All right, so I'm going to place you both under oath, and I've got some questions that I need to ask both of you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you both would raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Okay, thank you. You can lower your hands. Mr. Burr, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown in your marriage relationship such that the objects of matrimony have been destroyed and that there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you signed the complaint?
Yes.
Does that remain true today?
Yes.
And how many children were born of this marriage?
1.
Okay, and under this proposed judgment of divorce, it provides that you would share joint legal and physical custody of your child with Ms. Burr, is that correct?
Yes.
And in terms of the payment of any child support, the part you both opted to exempt this case from friend of the court services that was approved by the court by a prior order. And that means that in terms of payment of any support, that's not going to be monitored by the friend of the court, and that'll be up to you and Ms. Burr. Is that how you want to proceed in that regard?
Yes.
And as the father of your child, do you agree that those provisions would be in your child's best interest?
Yes.
Okay. And in terms of property division, you and Ms. Burr submitted a proposed judgment to this court that provides for dividing up all the assets and debts of your marriage. And you have signed that as Ms. Burr. Are you asking the court to enter that as a judgment? And are you agreeing to abide by the provisions of that judgment in terms of how your property and debts will be divided?
Yes.
Okay. And as part of the judgment, you're not going to pay or receive any kind of alimony or spousal support. Is that correct?
Yes.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
Okay, thank you. Ms. Burr, were you able to hear all the questions that I asked of Mr. Burr?
Yes, I did.
And were you able to hear all of his answers?
Yes, I did.
Do you have any reason to believe that any of the answers that he gave were untrue?
No.
And in terms of custody and support of your child, do you agree that entering the order as I've indicated would be in your child's best interest?
Yes.
And are you agreeing to and willing to abide by all the provisions in the judgment regarding the division of the assets and debts of your marriage with Mr. Burr?
Yes,
As part of that judgment, you also will not be paying or receiving any alimony or spousal support. You understand that you also would be waiving that forever, and you would not be able to come back later and ask the court for that.
yes, I understand.
Are you currently pregnant?
No,
Okay, thank you. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. I have reviewed the proposed judgment. It does comply with statute and court rule. The court will grant the divorce. I'm signing those documents with today's date. Ms. Burr, you're asking to have your last name changed, is that correct?
yes, for sure.
Okay, so because the divorce is going to be final today, your name will be legally changed from today forward. A copy of this proposed judgment or entered judgment now is available for you at the clerk's office if you need a copy of that to change your identification and other documents, okay?
Great, thank you.
Mr. Burr, did you have any questions at all?
No, I don't.
Ms. Burr, did you have any questions?
I don't think so.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you. Hmm.
All right, looks like we have both counsel connected. We'll go on the record in Hoffman versus Wilson. And this is case number 2219015. If I could have both counsel put your appearances on, starting with the plaintiff, please.
Good morning, Judge. Elliot Blumberg on behalf of Cheyenne Hoffman, who's appearing via Zoom from my office.
Craig Elhart on behalf of Mr. Austin Wilson.
Okay, Mr. Elhart, were you anticipating Mr. Wilson connecting here? I don't see him in the waiting room.
I do not, Your Honor. Mr. Blumberg and I have come to an accord and have executed a consent judgment divorce. We're asking that pro confessor proofs be placed on the record this morning by the plaintiff.
Okay, Mr. Blumberg, were you ready to take proofs from your client?
Yes, Judge, we are.
Okay. All right, Ms. Hoffman, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand, and Mr. Blumberg, proceed whenever you're ready.
Thank you, Judge. Cheyenne, please state your full name for the record, please.
Cheyenne Dakota Hoffman.
And you are the plaintiff in this action for divorce, is that correct?
Correct.
In July of 2022, you filed a complaint for divorce, and in it you allege that on September 8th of 2018, you married Austin J. Wilson in Otsego County, Michigan. Is that correct?
That is correct.
And further, that ceremony was performed by an individual who was authorized for marriages. Is that correct?
Yes.
In your complaint, you allege that you had been a resident of the state of Michigan for at least 180 days immediately preceding your filing. Is that correct?
Yes, that is correct.
And you've been a resident of Otsego County for at least 10 days immediately preceding the filing. Is that correct as well?
Yes.
There are two children currently of this marriage, Boyd and Scott. Is that correct?
Yes.
And you and your husband have come to an agreement that you are going to share both joint legal and joint physical custody of those kids. Is that correct?
Yes.
And there's a parent time schedule that effectively gives each of you 182.5 overnights. Is that your understanding?
Yes.
In your complaint, you allege that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Yes.
And is that true today?
Yes.
You are not currently pregnant, are you?
No.
Now, you and your husband have agreed to a property settlement. There is no real property to be divided in this matter, is that correct?
Correct.
And that you have all of the personal property that you're going to be awarded in your possession, as he has all the property he's being awarded in his possession. Is that correct?
Yes.
You understand that neither you nor your husband are seeking spousal support, meaning that there's no alimony and you can't come back at a later time to ask the court to revisit that issue. You understand that?
Yes, I do.
Okay. In terms of the custody arrangement and parenting time, do you believe that that would be in the best interest of your children?
Yes.
And again, as it relates to the property division and debts in this case, do you believe that to be both fair and equitable?
I do.
Are you asking the court to ultimately sign the proposed judgment that's been circulated, dissolving this marriage?
Yes.
Thank you. I have no other questions, Your Honor.
Thank you. Mr. Elhart, did you have any questions for Ms. Hoffman?
No questions, witness. Thank you, Your Honor.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Hoffman. The court will grant the divorce. And I'm assuming counsel's going to submit that, if they haven't already, to the court for signing.
Yes, Judge. Everybody has signed it. We're waiting the friend of the court's approval.
Okay, thank you. Mr. Blumberg, anything further on behalf of your side today?
No, Judge. Thank you.
Mr. Elhart.
No, Your Honor, I simply want to thank the court for its courtesy in allowing me to attend today, and Mr. Blumberg for his courtesy during the entirety of this litigation.
The whole thing, even the part when we were mad with each other for a couple of days there?
We still love each other, Elliot.
Okay, thanks.
You guys are great. Thank you. I don't know what else to add to that. I'm just going to leave it at that. Everyone's free to disconnect. Mr. Blumberg, I'll just put you back in the waiting room. I know you got the 10 o'clock coming up.
Thanks, Judge.
Okay, thank you.
Okay, we're all set. All right, I'll send you a
Mr. McFerrin, are you there?
Yes, Your Honor.
All right, your hearing was set for 9:45. It was removed from the docket last week. The court issued an order on one of the prior motions in there dismissing your case against Ms. Guiana. So that case your hearing was taken off the docket for today. You should be receiving a copy of that order if you haven't received it already.
I just filed a bunch of evidence into the courtroom this morning and then making a mention of it.
Yeah, I'm not sure what interactions you had, but there's a written order that, again, disposing of the case that you should be receiving shortly if you haven't already received it.
Dismissed because of.
I'm sorry, you broke up there.
Dismissed because of what, Your Honor? I'm just not following why we didn't wait a week to.
Yep, the written order will explain everything. So when you get that, you can read that.
Did it have anything to do with me suing the court and you as a defendant?
I don't have anything else to add other than what's in my written order, so you can read that. So I'm going to go ahead and disconnect at this time. Thank you.
Say it out loud.
Okay, looks like we have both counsel connected. We'll go on the record now in Tomasky versus Tomasky. This is case number 2319198. If I could just have both counsel put your appearances on, please.
Good morning again, Your Honor. Elliot Blumberg on behalf of Ms. Tomasky, who is seated in my office appearing via Zoom.
Good morning, Your Honor. Mark Dundon appearing on behalf of Mr. Tomasky, who is appearing via Zoom from his office.
Okay, and I see we do have Mr. Tomasky connected. This is set for a status conference today. The last time we met was back in November. Mr. Blumberg on behalf of plaintiff, where are we at?
Well, regrettably, we're not quite ready for mediation yet. We're waiting for a business valuation report to be completed. Once we get that, then we've agreed and you've ordered us to go to mediation, and hopefully that will resolve much of the personal and real property issues.
Okay, how much time out do you think we should set for the next hearing?
I would think 45 days should be sufficient, maybe 68 at the outside.
Okay, all right, thank you. Mr. Dundon?
That's fine, Your Honor. Again, my client's turned over what he can, which Mr. Blumberg acknowledged last time. So yeah, we're waiting for them to do what they need to do as far as business, any business valuation. But yes, we'd like to mediate as soon as possible. But if they need 45 to 60 days, that's fine, Your Honor.
Okay, so we'll I'll have it set for mediation to occur within the next 60 days. I'll set it for a status conference at that point. If we have an agreement, we can use that time to enter proofs and finalize things. If not, we can do further scheduling. Mr. Blumberg, anything further we need to address from your side today?
I don't believe so. Thank you.
Mr. Dundon?
No, thank you, Your Honor.
Okay, thank you. That's all for today. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Ms. Wood, are you there?
Yes, I am.
Okay, are you still represented by Ms. Doak? Is she gonna be appearing on your behalf here today?
Yes, she is.
Okay. I don't see her in the waiting room. This hearing was set to start at 10:15. I also don't see Mr. Tubbs. He is also not appeared. So it's my view that we should just continue on with the arrangement that we currently have. Do you have any objection to that?
I'm sorry, could you please repeat that?
I said with Mr. Tubbs not appearing today, then the court would just continue what the arrangement that we currently have in place.
And that is the Tuesday, Sunday and Tuesday supervised visitation?
Correct.
Well, I wanted to speak to you about that because he hasn't showed up for, let me see, for 19 visits. He only showed up, January 21st till yesterday. And he hasn't been like interacting with the child or anything. Like I have evidence of all that stuff. So he's not really interested in the visitation. So I don't want to waste my time. Go in there for 3 hours and he's turning his back to Jaden and not paying Jaden any attention.
Ms. Doak is just joined in, so hold on one second.
Okay.
All right, we have Ms. Doak present now. So Ms. Doak, I was just talking to your client. I didn't know if you were going to appear or not.
Sorry about that. For some reason I had 10:30 in my head and it was 10:15. I apologize. I'm here.
So I noted for the record that Mr. Tubbs hasn't appeared today. So the purpose of this hearing, as you're aware, was for the court to determine whether there should be any more parenting time or unsupervised parenting time. Ms. Wood is just notifying me that Mr. Tubbs has not been really exercising the parenting time that he does have. So certainly within that appearing today, it wouldn't be my intention to increase his parenting time at all or make it unsupervised. To the extent that Ms. Wood wants to, change that order, I think that would have to be by motion and have that set for a hearing. If she wants to, eliminate the supervised parenting time that is not being exercised.
I just wanted to, I don't know what was said when I was gone, but he just started showing up at the end of January and has come to 5 visits, but does not participate. So he just sits and watches. He puts some toys on the ground and just watches. That's my understanding of what's going on.
Okay. Yeah. So, I mean, if you want to, again, if Ms. Wood wants to seek to change that parenting time from what it is, I'm just going to order that it continue for now as it is. And again, if you want to make changes to that, then just file a motion and set up a hearing and we'll see where we go.
Sure. Just as a matter of clarity, Your Honor, I didn't understand my clients were doing this, but from November until he showed up in January, they went to the place for the visit and stayed for the full 3 hours. And I can understand why they might read it that way, but would the court agree that if they wait 15 minutes and he doesn't show up, that would be sufficient for them to be able to then leave?
Yeah, I mean, I think that's fair. I don't think they should just have to sit and wait for the entire time if he's not going to be there. I think 15 minutes is a reasonable time for him to be there or not be there.
Okay. Thank you, Your Honor.
Yeah. Okay.
All right.
All right. Okay. Thank you. That's all for today. I'm not going to set any further hearings in this matter. And again, Ms. Doak, if your client wants to change the parenting time from what it is, then I'll just look for a motion on that.
Appreciate it. Thank you, Your Honor. Will do.
Okay. Everyone's free to disconnect. Thank you.
Thank you.
All right, we got somebody on the phone with the last four digits, 1346. Can you tell me your name, please?
My name is Ethan Robertson.
Mr. Robertson, okay. I've actually got your hearing set for 10:45, so you can hang up and dial back in, or I can put you on hold.
It's all right to put me on hold.
Okay, sounds good. Thank you. Okay, Ms. Weber, I just need you to unmute, please. All right, thank you. Can you tell me your name, please?
Serena Weber.
Okay, we're on the record in Weber versus Weber. This is case number 2319475. Ms. Weber is present today by Zoom video. This hearing was set for 10:30. It's now a little bit past 10:30. I don't see Mr. Weber present. Have you had any contacts with Mr. Weber recently? Do you know why he's not hearing today?
He's at work, but he should be getting online soon.
Okay. All right, I'm going to give him a couple more minutes to connect, so I'm just going to put you on hold here for just another 2 or 3 minutes, okay?
Okay,
All right, thank you.
you're welcome.
All right, Mr. Renkevich, are you able to hear me okay?
What's that?
Are you able to hear me okay?
Yeah, I'm able to hear you okay.
All right, we're on the record in Renkevich versus Renkevich. This is case number 2319259. This is set for a status conference today at 10:30. It's now a few minutes past 10:30. I do not see Ms. Renkevich joining in. Have you had any contact with her recently? Do you know why she's not here today?
I just seen her Sunday. The whole mediation process has actually been a real pain because she constantly did not want to do it in Otsego County. So she tried to make me do it in Petoskey, even though you guys had it set up. I had it set up in Gaylord, and she finally just actually budged on it. So we didn't do any of the mediation because of her. So I would like to have it extended if I could, please. But she just said she's willing to do it in Gaylord. Last week.
Okay, so what I'm going to do is order that mediation occur. I'm going to put in the order that it has to happen here in Gaylord. There's no reason why it needs Petoskey, and we have the service right here. So I'll put that in the order. So, you know, basically neither of you has a choice. It needs to happen in Gaylord. And then I'll set this for another hearing after that. If she continues to refuse, then the court may issue some sanctions because this needs to get done. I'm sure you both want to get this resolved.
Yeah, which it was just a pain really, because I had everything set up. I paid the money, and now I have to repay. They said possibly. I'm just like, it's just time wasted pretty much because she wanted it her way, and I was like, it was set up in Gaylord. You know, why are you have to do this in Petoskey? It doesn't make sense. But yeah, I appreciate extending this.
Okay, so I'm going to refer it back to them. They should be back in touch with you to set up a date and time, okay?
All right, sounds good. You have a great day.
All right, thank you. Okay, Ms. Weber, I still don't see Mr. Weber joining in, and
He says,
so I got. Oh, go
he
ahead.
says he's in the waiting room.
He's not. He might be in the wrong place. I'm not sure, but he's definitely not in my waiting room.
Okay.
So I've got to move on because I have other cases waiting. But I'm going to set this for another hearing. The purpose of this hearing today is just to determine whether or not I know you've got some custody hearings that are set to occur later this month on February 14th. The purpose of this hearing is just to determine whether or not there's any issues regarding dividing up any marital assets or debts. Just from your standpoint, have you guys been able to make any agreements on those kind of things?
Yeah, we already made an agreement.
Good. Okay. All right. So I'm going to set this for another hearing after you have that hearing at the front of the court, and then we'll go from there. Okay.
Okay.
All right. Thank you. That's all for today.
Thank you.
Okay, excuse me, Mr. Robertson, are you still there?
Yes, I'm still here.
Okay. Ms. Robertson is signing in, so we're a little early, but we can go forward with your case.
Okay, thank you.
I'm just waiting for her to sign on right now, so if you'll just keep holding here.
Of course, not a problem at all, Your Honor.
Hello?
Ms. Robertson, are you there?
Yes.
Okay, great. We're on the record now in Robertson versus Robertson. This is case number 2319524. We have both parties connected here today remotely. The purpose of this hearing is to set some scheduling dates to determine whether I know you've had some hearings regarding child support, custody, and so forth. This part of the case is regarding any marital assets or debts, and whether you guys have reached any agreements or whether there are still areas of dispute on that. Ms. Robertson is the filing party here. Have you been able to reach any agreements as to how to divide up any assets or debts?
Yes. We have all that settled and we agreed upon everything.
Okay, Mr. Robertson, do you agree with that?
Yes, with the things that we have discussed, we do agree upon it, Your Honor.
Okay, from your standpoint, Mr. Robertson, are there any outstanding issues or things that still need to be agreed upon?
As far as I know, see, and understand, I'm fairly confident that everything that's been discussed between us has been pretty much hammered out, Your Honor.
Okay. All right. So you filed this case at the end of November. By law, the court has to wait 6 months before I can finalize the divorce in this case. So if there are no disputes that the court needs to decide, then I can set this for a final hearing right at the end of that 6-month period, and then we can finalize the divorce. Ms. Robertson, is that how you'd like to go forward?
Yes.
Okay, Mr. Robertson, is that okay with you as well?
Yes, Your Honor.
Okay, so I'll set it for that final hearing date. What I'm gonna need both of you to do between now and that final date is there are two forms that I'm gonna need prior to that date. One is called a judgment of divorce. And so wherever you got the documents to file for divorce, you can get that form there, whether that was online or somewhere else. But it's called a judgment of divorce, so I'll need you to get that, fill that out and submit that to the court. And then also from the friend of the court, a final order regarding child support. So I'll need you guys to get those two things, submit those before that final hearing, and then we can finalize things. Ms. Robertson, did you have any questions about that?
I don't believe so.
Okay, Mr. Robertson, any questions from your side?
No, Your Honor. It's pretty self-explanatory from here.
Okay, all right, so the court will send you both notice of the date and time of that final hearing. It'll be by Zoom, just as we're doing today, and then we'll go from there. That's all I have. You're both free to disconnect at this time.
Okay.
Thank you, Your Honor.
Thank you. All right, we're on the record in Martin versus Fournier, case number 23-19345. This was set for hearing at 11 a.m. this morning. It's now almost 11:05. Neither side has appeared by Zoom or otherwise. So this is a hearing on an objection to the referee's recommended order. First of all, the court's going to dismiss the objection based on the failure of either side to appear here today. But then looking at it more on the merits, the court finds that the objection was untimely. The objection wasn't filed until December 19th, and the referee's recommended order came out on November 15th. And so the objecting party did not file her objection until after this had actually become an order of the court on December 12th. So the objection is untimely under any circumstances. So the court will dismiss the objection. The court will issue an order denying the objection and dismissing it. Our next hearing is set for 11:15. Okay, looks like we have everybody connected. Miss Lasher. Okay, yep, I just need both of you to unmute then, please.
Okay.
All right, are you guys in the same place?
Yes.
We're gonna have a lot. Yeah, so we're gonna have feedback because your devices are gonna be competing with each other on the audio.
Can we just get on the same one?
Yeah, that's fine. That's no problem. Okay. There we go. That's going to give us much better audio. Thank you. All right, we're on record in Lasher versus Lasher. This is case 2319538. We have both parties present by Zoom video here today. The purpose of our hearing here today is for the court to just talk to both of you, find out if there are any disputes over the division of any marital assets or debts that we're going to need to set hearings for, or whether you've been able to reach some agreements on those issues. So Ms. Lasher, you're the filing party here. Can you speak to that for me?
Yeah, we agree on everything for the divorce. We have nothing we're fighting about over at all. We both want the divorce to go through. We not arguing or anything.
Okay, Mr. Lasher, do you agree with that?
Yep.
All right, and have you guys been able to reach? Did you have a hearing at Friend of the Court last week or the week before?
Yeah, we did it over Zoom. But with her current living situation, we're still living with me right now. She's looking for a place. They set a new court date for next month to see how her situation's going, because she's trying to find a place right now. So with that going on, they're trying to give her a little bit more time before, so we can, because we're in agreement with what we're doing with the kids also. But with her living here, it kind of makes it difficult to put into effect, I guess, a plan of action.
Yeah, okay, all right. So what I'm gonna do then is set this for a final hearing where we can finalize the divorce. Under Michigan law, you have to wait 6 months before we can do that. Your divorce was filed at the beginning of December, so I'll set this for the soonest date following the expiration of that 6-month period, so it'll probably be in June. And then we can finalize things at that point. The only thing I'm gonna need the both of you to do prior to that hearing, there's a form called a judgment of divorce, and you can find that wherever you got your other forms to file for divorce in this case. But that's the final document or form that closes the case and finalizes the divorce. So I'll need you both to fill that out and submit that to the court prior to that last hearing date. And then from the Friend of the Court, you'll just need a final order from them about the child support issue, which they'll be able to give you probably at your next hearing if you agree on everything. So you just need to submit those 2 documents prior to that final hearing date, and then we can close everything out and get the divorce done on that date. I will, on behalf of the court, send you a notice of the date and time for that hearing. It'll be by Zoom, just like we're doing today. Do either of you have any questions about that process?
Nope.
Okay, so yeah, the most important thing is for you guys to get those documents in prior to that date so that we can finalize things then. And otherwise, just look for that date in the mail. And that's all I have for today. You're both free to disconnect at this time.
All right, thank you.
right, Mr. Blumberg, do you have your client there with you?
I do, Judge, yes.
Okay, all right, we're on the record in Boer versus Boer, case number 2319356. We have Mr. Boer connected by Zoom video. Mr. Blumberg is also connected with his client present with him. This is set, I believe, for a status conference in this case today, and for some scheduling. I don't think we've had a previous hearing. Mr. Blumberg, on behalf of plaintiff, can you tell me where things are at from your side?
Sure, Judge. On December 5th, Mr. Boer was defaulted in this matter. He, however, filed an answer about a week and a half later. So from a procedural standpoint, I think he's still in default. That having been said, there are not much has happened. Both sides have filed their verified financial statements. I guess at some point we would ask the court to order us to mediation. Mr. Boer, if he's going to represent himself, I'm prepared to sit down and talk to him and try to resolve the issues. But right now, everything is pretty much up in the air.
All right, Mr. Boer, from your side?
Yes, Your Honor. What's the question? I'm sorry.
Do you have any objection to participating in a mediation process to see if you can all reach an agreement as to the division of any marital assets or debts?
No objection, Your Honor.
Okay, and do you believe that you'll be representing yourself throughout this case?
That's correct.
Okay, all right. Mr. Blumberg, 60 days for mediation, 90, what's your thought on that?
No, I think 60 days would be sufficient. I think we have an idea of what all the assets are. We just need to sit down and figure out how to resolve some of the issues.
Okay, Mr. Boer, do you have any objection to that?
No, Your Honor.
All right, so I'll just order that discovery to remain open, mediation to occur within the next 60 days. Mr. Blumberg, just looking through the file, and maybe it just hasn't made it in yet, I don't see the default in here, so that might be an issue that you want to address going forward.
Sure.
But let's do mediation. Let's see where we're at by that point. I'll set it for another status conference at about 60 days, and we'll go from there. Mr. Blumberg, on behalf of plaintiff, anything else that you'd like to address here today?
I don't think so, Judge. Thank you.
Okay, Mr. Boer, did you have any questions or anything else that you wanted to address here today?
Only regarding the default, Your Honor. I'm not sure if that's going to be continued or thrown out. If it's going to be continued, then I would like to explain the events that led up to that mistake on my part.
Okay. It doesn't sound like it's a real issue at this point. I guess we'll see where we go with that. I think if the parties are able to reach an agreement in mediation, then it'll probably become a moot point. But I guess we'll see where we go with that part of it. And you're free to have those discussions with Mr. Blumberg as well as part of the negotiation process. So, okay, the court will set a status conference. We'll send out notice of the date and time of that. That'll be by Zoom, just as we're doing today. And that's all I have. All parties on this file are free to disconnect.
Thank you, Judge.
Thank you.
We got somebody. There she is. She's right there.
All right, looks like we've got everybody connected, so we'll go on the record. This is Stephanie Jones versus Austin Woodworth, case number 2319462 DS. Looks like we have both parties connected by Zoom, as well as Mr. Rolla on behalf of the state of Michigan. And Mr. Rolla, this is the date and time set for entry of a default judgment of support. I I did receive a proposed judgment. Was there anything that you wanted to state on the record in support of that?
Yes, thank you, Your Honor. For the record, Mike Rowland, on behalf of the state of Michigan. Our office is still requiring to get valid current phone numbers for Ms. Jones, and as far as also Mr. Woodworth, because the numbers we have come back not valid numbers, so we'd ask the court include that information. And as Ms. Jones didn't sign the proposed order, we're going to need the court to take some testimony from her before the order can be entered. Thank you, Your Honor.
All right, Ms. Jones, can you unmute yourself, please?
Yes, I can. And I'm sorry, I have my kid at the moment. So it's okay, Book.
All right. Ms. Jones, can you give us a good phone number for you?
Yeah, it'll be 989 470-8974.
That goes straight to.
Okay.
That goes straight to
And
voicemail.
It shouldn't go right to voicemail. 989-470-8974 is my phone number.
It doesn't go to voicemail. It says it's not no longer active.
It now indicates as of apparently today, it's no longer active. So you may want to check on that. What is the address that number is attached to, ma'am?
9311 Old 27 South, apartment 32.
Okay, that's what we have. Yeah, it says that the number is no longer active, so you may want to check on that.
Yeah, I'll definitely check on that because it shouldn't be.
All right.
All right. And
So
Ms.
phone number and address for Mr. Woodworth, please.
Yeah, I'll address that in a second. I'm going to go one at a time here.
All right, thank you, Judge.
Ms. Jones, you're the mother of Bo Edward, is that correct?
Yes.
And you understand that this proposed order here today would give you joint legal custody with Mr. Woodworth of your child, and that you would have primary physical custody with parenting time for Mr. Woodworth as agreed upon by the parties. Do you understand that as well?
Yeah. Yes, I do.
And that this order would also provide for payment of child support by Mr. Woodworth.
Yes.
Okay. As a mother of your child, do you agree that entering these orders today would be in your child's best interest?
Sometimes, yes.
Okay, well, I can't have the order be in effect.
Yes.
Sometimes it's either be in effect or it's not, so I just need to know.
Yes.
Okay, all right, thank you. Mr. Woodworth, can you unmute, please?
Yes, sir.
You're Austin Woodworth, is that correct?
Yes, Your Honor.
All right, and you're the father of Bo Edward, is that correct?
Yes, Your Honor.
Okay. You understand that you were defaulted in this case because you didn't file any kind of answer or response. Are you objecting to the entry of these orders today?
I'm not sure what that means, if you could help me understand.
Sure. So the prosecutor's office provided you with or served these documents on you. You failed to respond to those. And so in order for you to contest this, you would have to file a motion to have the default set aside. I'm just trying to determine whether that's something that you're going to do or whether you agree with the entry of these orders today.
I understand I didn't turn it in. I just don't know is there consequences? Like, I don't know what's the action of me not turning it in or something. That's what I'm having a hard time understanding.
Yeah, so that would require me to give you legal advice, and I can't do that because then I would be, kind of
right. I just don't know what I'm saying yes or no to is what I'm saying. Like, I have no idea what that means or anything.
Yeah, so you probably, when you got these papers, you probably would have wanted to investigate that before today.
Right. I just know when I did get said papers, I was going through moving out a roommate and a lot of things were going on. So I didn't really lot of things got misplaced, and I just started getting my mail again yesterday, so I haven't really got a lot of things.
Your Honor, if
Yeah,
it's some
well-
assistance perhaps to Mr.
No,
Woodward.
no, we're fine. I'm not gonna overcomplicate things here. So I guess, Mr. Woodworth, you've been defaulted, so the court's gonna enter these orders today. If you have questions about the legal effect or the consequences, then my advice to you would be to seek a lawyer to help you explain those things to you so that you understand and give you whatever options you may have going forward, all right?
Okay.
And can you give us your current phone number, please?
It's gonna be 989-448-6066.
Mr. Roller, were you able to get that?
448-6066.
989-448-6066.
Yes, thank you. And the address that that number goes with, sir?
It should go to 7346 Old 27 Highway North, Trailer 16.
Thank you.
Thank you.
All right, thank you. Mr. Rolla, the court signed those orders, and that's all we have for today. All parties on this case are free to disconnect at this time.
All right, thank you, Your Honor.
Thank you. All right, that's our last remote